The first presentation to kick off this series is the patenting process from an idea to issuance and everything in between. And this will be presented by Brad Taub and Ariel Roth. Brad is a veteran EIA speaker and mentor. He has been at EIA this is technically his 4th year. And Ariel is a rookie, so everyone be easy on her. But I guess we'll just get it started.
Thank you for the introduction, Ella. My name is Bradley Taub. I'm a mechanical engineer by degree. I love learning about all kinds of new technologies, whether it's building, as you can see, some Lego sets, or just taking things apart, figuring out how they work. I love it. So that's why this job's great for me. I'm a patent attorney at Nixon Peabody. I've been doing this for about 13 years. I've worked on over 1,000 different patent matters, a lot of them in the US, but also we do a lot of work all throughout the world at many different countries. Fun fact, last few years I've been an amateur low-carb chef. Here's an example of something that I made, no sugar, but it still does taste great. And my most important role is a dad to these 3 babies, Mickey, Ellie, and Finn, who's our most recent addition during this global pandemic.
Oh, hi, everyone. My name is Ariel Roth. Ariel, like Disney's Little Mermaid, but definitely above the sea, because fun fact, I still don't know how to swim. I have a physics degree and I'm also a patent attorney at Nixon Peabody. So like Brad, I have always been fascinated by new technologies, and I do a lot of things Brad does, and our practice is fairly similar, although I'm a little bit younger than him. And I have a 9-month-old fur baby. Her name's Bobby, and here are some pictures of her.
Okay, great. Thanks, Ariel. So Ariel will come back later to walk you through part of the presentation. So what are we going to cover today? So first, we're going to talk about, you have an idea, now what do you do with it? Then we'll talk about what is the typical path of an inventor from when they have the idea to getting a patent. We'll talk about what are the different types of intellectual property or IP that you can get to protect your idea in your company. We'll talk about what is a patent. We will demystify some myths, and for this part, we'll try and make it a little interactive using the Q&A button. So if you guys in Zoom open up the Q&A tab, you can respond to our questions. And then Ariel will come back at the end to give you some tips about figuring out if your invention is patentable. So what do you do with an idea? This goes back to when I was living at my parents' house before we moved into our current house, and I was reading our eldest daughter, Nikki, a book every night, and we still do that. And I found this book just laying there on the shelf, and I said, oh, what do you do with an idea? Is this for Mickey or is this for me? And I thought, you know, how would I answer this question? Well, as a patent attorney, my answer, maybe not the greatest, but let's look at your idea and figure out if we can get you a patent. Let's protect it. The book's answer, much better. You change the world with your idea. So now I've revamped my answer to this question is let's look at your idea, evaluate it, see if we can get you a patent so that you can go out and change the world with your patent. Okay, the typical path of an inventor. This starts with conception. Conception is the eureka moment. That's when you either wake up in the middle of the night, the light bulb goes off on the top of your head. Aha, I figured it out. If you conceived of the idea, you are the inventor. In order to be an inventor in a patent, you only need to have conceived of just one idea in the patent. Then the next phase is what I like to call internal reduction to practice. So this is where you by yourself or you work with some colleagues, possibly a co-inventor, and you try and make your invention. You try and work out the kinks, figure out, is this feasible? And then this is where you might discuss it with other people. And during that discussion is often going to lead to additional conceptions of additional related ideas. And then often, at some point, you're going to need to go outside of your company, outside of the inventor circle, and maybe talk to a potential client or a third party. And that's totally fine. But to make sure that you maintain the secrecy and the confidentiality of your invention, you definitely want to do what's called a non-disclosure agreement or an NDA. And you want to enter into that before you disclose your invention to anybody outside of your company. And now this will protect you against what's called a public disclosure of your idea. It will not protect you if you were to offer to sell your idea. So after you've kind of fleshed out your invention and you've determined that it's feasible and you want to move forward protecting it with a patent, the next step is preparing what we call an invention disclosure form, or an IDF. This is going to serve as the foundation for your patent application. So what do you include in this? And most companies have like a standard template IDF. We work with a lot of different companies, and sometimes we provide them with one. But initially, you're going to want to have the background section. Now, the background section is going to talk about what was done before your invention and what are the problems with it. What were the shortcomings of what people were doing before? And then you'll want to try and frame this as a technical problem. What is the technical problem that you are solving? And the background section is really very important because it's going to provide the context for your entire invention to follow. So after you have the background laid out and you identify the technical problem that you need to solve, you're going to talk about the invention itself. And you're going to start by saying, hey, the technical solution to the technical problem is blank. This is where we want to clearly explain how your invention is new and not obvious in view of the prior art. You really want to highlight how does your invention solve those problems and those deficiencies in the prior art. And this is going to be very helpful to us as patent counsel because this is going to tell us how to focus the claims, which come at the end of the application, which are the most important part. And the claims are what defines your invention. So very important part. The more detail you can provide, the better, but you don't have to write a novel. We can actually take, you know, a paragraph or a couple paragraphs, whatever you have, and turn it into an application with you. After you have the text, very important are charts, diagrams, flow charts, things like that, any kind of pictures that can help depict your invention. Whatever you can do, very helpful. And then the next part is if you're aware of any prior art or any other patents or publications that are similar or close to what you're doing, you actually have a duty to provide that to the patent office. So you want to include that in your IDF. You do not have to go out and do a search though. That is not a requirement. And then once you're done filling out your IDF, you'll submit it to patent counsel. We'll review it, provide comments, maybe some questions. Sometimes we will order an outside search if we think maybe there's some close art. Again, not a requirement, but sometimes we do that. And then almost always we'll have questions. So we'll set up nowadays a Zoom call where we'll go back and forth with you and we'll kind of help flush out and answer any of our questions to get to the point where we're ready to draft the claims. Again, the most important part of the application. This defines what your invention is. So we'll draft the claims. We'll present them to the inventor. The inventor will review them, make sure they're accurate, make sure that there's nothing missing. So you'll provide comments back to patent counsel. And then once the claims are approved, then we write the rest of the application. So that includes the specification and the drawings. Once the full draft of the application is complete, we'll send it back to the inventor. The inventor will review it one more time, provide any additional comments, and then we will file the application. And once we file your application, you are now patent pending. So the great marketing tool that everyone talks about, patent pending. Once you file your application, you are now patent pending, and you can go out and tell everybody, I'm patent pending. So what comes next? You filed your application, now what? Are you done? No. Typically, we're gonna wait. And we're gonna wait sometimes a while. In the US, if you file a non-provisional application, sometimes nothing will happen for 1, 2, maybe even 3 years. Now, there's ways to speed that up, of course. You might imagine if you pay the government an additional fee, they'll look at your application sooner rather than later. But a standard filing, you're probably going to wait at least a year and a half, maybe even 2 to 3 years. Then, almost always, and this is at least 90% of the time, if not more, the Patent Office, the USPTO, which is the United States Patent and Trademark Office, is going to issue a rejection. And this is where they say, hey, thanks for your application. We reviewed it. Unfortunately, we're not granting you a patent, and they will give you reasons why. So totally normal, totally expected. Very rarely, initially, they will say, oh, this is great. We're going to put this through. But almost always, again, 90+% of the time, we're going to reject it. Then we have the negotiations. And this is a back and forth between the inventor and patent counsel with the patent office. And the negotiations go something like, okay, I see you've rejected my claims. However, we disagree, and we can provide arguments to the office, or sometimes we might make some tweaks to the claims to help our arguments get around the prior art. And once we do our job correctly, in the end, we're going to get that notice of allowance. This is that paper that we're all looking for. This is when the patent office says, hey, you know, good job. Your claims are allowed. They are allowed over all of the prior art that's out there, and you are going to get a patent. You just have to pay a fee. So once you pay the fee, your patent's going to grant 1 to 2 months later. And now we can go to the courthouse if we need to, and we can enforce our patent rights. So that's from idea to patent. Now let's talk about what are the different types of intellectual property, or IP for short. So as you can imagine, there's patents. There's a couple different types of patents. The first type of patent, the main one, is called a utility patent. And a utility patent is used to cover a device or an apparatus or a system. So kind of like this robot right here. This is a device or a very complicated system. You would get a utility patent to protect that invention. And the term of protection is 20 years. And that goes back from your filing date for 20 years for utility patents. Then if you have a design and you want to get a design patent, you can do that. The term of protection for design patents is shorter, it's 15 years, but it's from when the patent grants. And so these are for covering designs. Then the next type of intellectual property we have is for an original work of authorship, like a book, music, a painting, or a sculpture, like the statue of David here that I took a couple years ago when I was allowed to travel. And we protect original works of authorship with what we call copyrights. And the term of protection for a copyright, much longer. It's the life of the author plus 70 years. Then we have what's called a trademark. Now, a trademark is for the branding of the company name, the name of the product. You might recognize Coca-Cola. That is their trademark. Often, the trademark can be or become the most valuable asset of the company. If I wanted to create Brad soda today and I put the exact formula of Coke in there and tried to sell it, you'd imagine you would pass that up on the shelf and you'd want to buy Coca-Cola because of the trademark. Trademarks last forever as long as you continue to use them. And then the last type of intellectual property that we're going to talk about briefly here are trade secrets. Trade secrets, like trademarks, will last forever. They have unlimited protection as long as they're maintained as a trade secret. So how do you know if you're going to do a trade secret versus a patent? It boils down to, is your invention something that can be readily reverse engineered or not? If you're selling a widget and people can look at the widget and determine exactly how you do it, then trade secret is not for you. If you're selling something where it's really complicated software and no one can really figure out what you're doing, then maybe you would maintain it as a trade secret and not give all the details in the patent application. One thing to keep in mind here is all of these types of IP, it's not a one-size-fits-all. So often your company and your inventions will be protected with a utility patent, also a design patent, and a trademark, and sometimes also a trade secret. So don't think like, oh, I can only do one of these. You can do all of them, or some combination. All right, but today we're going to talk mostly about patents. So what is a patent? So patents, an intellectual property right. It's granted by the government, and it gives you a monopoly. And the monopoly allows you to exclude others from making, using, selling, offering to sell, or importing your invention into the country. It actually doesn't give you the right to make or use or practice your own invention. It only allows you to stop other people from doing it. And this monopoly, it's not free. It's in exchange for your public disclosure of all of the details of your invention. It's a quid pro quo. So you have to give the public, in the form of your patent application, all the details so that someone of ordinary skill in the art can make and use and practice your invention. And if you do that and you meet other requirements, you will get a patent. And the monopoly, again, remember, it's not forever. It's a limited time. If it's a utility patent, it's 20 years from your first filing date. And if it's a design patent, it will be 15 years from issuance. So what are the main parts of a patent? You've heard me talk about claims. The claims come at the end of the application, and these define the legal boundaries of what your invention is. Each claim you can think of as a separate individual piece of property that you can use to assert against others. And then everything else in the patent application is just generally referred to as the disclosure. This is going to describe your invention in a lot of detail, and it provides a context to understand the claims. So everything is really about the claims. So we've talked about utility and design patents. Let's get into that a little bit more here. So a utility patent is to cover an invention's functional aspects. So think about how your invention works. This is for a physical device that actually has a function. And the words will form the protection in the form of claims. And you can see here an example of a claim. Whereas a design patent is going to be used to cover the aesthetics of something, how it looks, where pictures form the protection. And so because you're using pictures to form the protection as opposed to words, typically design patents are going to be more of a limited or more narrow form of protection because there's only so much broadening you can do with pictures. And you can see here the picture of the iPhone. Apple got design patents essentially on a rectangle with rounded corners. And if you might have heard of an Apple-Samsung debate about this, worth about $500 million in Apple's favor over a design patent. So design patents can be very valuable, even though they are generally more limiting than a utility patent. So what can you get a design patent on? Of course, the design of a shoe and purse, but not just physical objects. In fact, you can get a design patent on the user interface or the GUI. And you can see here, Google actually got a design patent on a portion of their landing page. So don't just think you can only get a design patent on a physical product. Now, design patents have a number of advantages over utility patents. One of the biggest ones is that if someone infringes your design patent, you get statutory damages, meaning you only have to prove they infringed. You don't have to prove that it actually damaged you. If you prove they infringed, you will get damages as set by the statute. Design patents are also less expensive. Typically, a design patent application to file is going to be somewhere in the neighborhood of $2,500 to $3,500, whereas a utility patent is going to be quite a bit more, $8,000 up to $15,000, sometimes even more. And also design patents typically are examined faster and will issue as patents faster, sometimes within a year, up to like a year and a half. Whereas, like I mentioned before, a utility patent could sit for 1, 2, 3 years. So it might take you even up to 5 years before a utility patent grants at the patent office. Unless, of course, you pay the patent office an extra fee. And then they'll look at it sooner. Okay, so let's talk about utility patents. There's two types of utility patents in the US. You've got your provisional application and you have a non-provisional application. So a provisional application is a great tool in the US. It's very informal. There's very few legal requirements. You could essentially file your sketches or notes on the back of a napkin. As soon as you file even a provisional application, you can tell everybody, hey, I'm patent pending. The provisional application is never examined by the patent office. It won't ever be published, and it will never become a patent. What it does is it gives you a placeholder with the patent office for 1 year, and it gives you 1 year to figure out, hey, am I moving forward with this or not? If you're not, then it'll never be published and it'll go away. No one will know about it except for you. If you're moving forward with it, you will convert it to a non-provisional. So non-provisional, this is very formal. There's a lot of legal requirements that we need to comply with. The claims in the non-provisional will actually be examined. There'll be that negotiation with the patent office back and forth. The non-provisional will be published, and then eventually it will mature into a patent. So there's three main legal requirements in order for an invention to be patentable in the US. The first one is it needs to have utility or it needs to be useful. And almost all inventions that we see meet that requirement. They have utility. The second requirement is it needs to be novel or new, meaning that there's not a single reference out there or a single device out there that does everything that you're doing. So that's usually not an issue. The one that we usually have the biggest fight with is the third one. Your invention needs to be not obvious or inventive. And what that means is that you can't have all of the elements of your invention. You can have them in multiple references out there, but the combination just needs to not be obvious to someone of ordinary skill in the art. So in the US, we've got this thing called a grace period. When you have an invention in the US, if you happen to make a public disclosure, if you forgot to get that NDA signed that we talked about earlier, if you make an offer for sale, you have 1 year before you have to file your application. Otherwise, you will be barred by statute. So once you have that invention, you want to keep it under wraps. You don't want to go and post it on Facebook. You don't want to write an article on it and publish it. You want to keep it quiet. You always want to protect what we call the secret sauce. As long as you do that, you will not trigger this 1 year grace period. Now, if you have to talk to somebody outside your company, then don't forget, get that non-disclosure agreement, and that will allow you to discuss the details of your invention if you need to, without it being considered a public disclosure. So this is a nice feature in the US, giving you a 1 year grace period. However, outside the US, in just about every country that most companies care about, there is no grace period. This is an absolute bar. You disclose it today, tomorrow you cannot file in Europe. So if you're going to be outside the US, no grace period. This is why it's super important to not disclose your invention to somebody outside the company. And if you have to, you want to get it in an application first. If you can't do that, then at a minimum, you have to get that non-disclosure agreement executed. Okay, so now let's try and do this Q&A session here. If you guys want to go into the Zoom controls, you can click on the Q&A button, and I'm going to ask you to ask your questions, but really give me the answer to this. So just to try and get a little interaction here. Okay, myth number one that we're going to try and bust here. I can file patents wherever and whenever I want. What do you guys think? Open up the Q&A and let's lock in your answers. Okay, it looks like we got a lot of smart people in this session. False, you cannot. Okay, let's talk about why. There's this thing called a foreign filing license requirement, and almost every country has it. And what this is there for is basically to prevent the export of really important military secretive inventions like nuclear bombs and things like that. So basically, if you have an invention that's conceived in one country, but you want to file it in another country first, most of the time you're going to have to go to the country where it was conceived, and you're going to have to get permission in the form of a foreign filing license. And if you do that, then you will be able to file in that other country first. And an important point to note here, for international teams, which is very common in with EIA, where you have inventors that are from multiple countries, even if you have one inventor that was in a different country, this will be a requirement for the entire application. Okay, next question. Let's see if you guys can stay on a roll. Super important question here. Is software patentable? Can I get a patent on software? What do you guys think? Lock in those answers. Can I get a patent on software? What do you guys think? Someone says copyright, someone says yes, it depends, someone says yes. Okay. This is a tough one. Let me tell you why. The answer is yes. Of course, we can get a patent on software. Lots of people get patents on software. Remember, design patents. You can get a design patent on the GUI or the icon, just like Google did, right? But it's not limited to design patents. You can also get a utility patent on software. Now, the algorithm or the code itself, no, you can't get a patent on an algorithm, but if you integrate the algorithm into a practical application, then certainly you can get a utility patent on that. And the way we do it is we focus on the steps that the software takes. So if you go through the code and you say, okay, step 1 is this, step 2 is this, and we can write the claims to cover those steps. And this is great because it doesn't matter what code someone else writes, as long as their code, whatever they use, does those steps, they will infringe on that claim. And in fact, the code is not even included in the patent. So definitely you can get a patent on software. And just don't take my word for it. There's a lot of software companies you might have heard about that get patents all the time. Microsoft has over 50,000 US patents, and over 4,000 of those are design patents. Google, over 29,000 US patents, over 700 of them are design patents. And Facebook, also a software company, over 3,600 US patents, over 100 of them are designs. Okay, myth number 3. Let's see if my Mythbuster friends can get this one. This one's tough. Okay, is a combination of all known elements patentable? Can I get a patent on a combination of only known elements? So all these elements you see here, these are all known. You've got a memory device, you've got a body, you've got a lens, you've got a display, you've got some chassis, you've got some chips, all known elements. A known element, something that's just known. People know about it. People know about all these elements. Can I get a patent on this combination of known things? Okay, let's find out. Yes, we can get a patent on a combination of only known elements. Think about it. Almost all inventions in modern times are just combinations of known things, right? We're not really coming up with new elements. I mean, certainly if you came up with a new element, then that would be something you can get a patent on. But almost all inventions that we're working on are just a combination of 3, 4, 5, 6, 10 different things that are already known out there. Now the test to see whether or not you can get a patent, and yes, someone just mentioned it correctly, is whether or not that combination is obvious to someone of just ordinary skill in the art. And this should be an objective test, all right? But really it's a subjective inquiry, and it matters based on the examiner's subjective inquiry here. So if the examiner of the application thinks of supposedly applying an objective measure that it is obvious to someone of ordinary skill in the art, then they would say, no, you cannot get a patent. You would not meet that third requirement. It would be, you would have utility, It would be novel, but it would be obvious. But if you can convince the examiner that that combination is not obvious, then you would be able to get a patent. And in fact, if you looked at those pieces carefully, you would see that they were for a digital camera. And Canon has been making digital cameras for a while. Cameras are known, they've been around for a really long time. Canon has over 70,000 US patents. But what's interesting here is that about 10,000 of those have come since 2017. And cameras have certainly been known for a really long time. And of those 10,000, about half of them, or about 5,000, are actually related to cameras. So Canon's able to get 5,000 patents in the last 3+ years on camera-related technology. Okay, this is our last myth, and then we're going to pass it over to Ariel to wrap it up. Myth number 4, this is a pretty tricky one. It even kind of trips up patent attorneys from time to time. Patentability versus freedom to operate, okay? So let's say we have an existing patent, and let's go back a number of decades, okay? This existing patent is on a car with an engine, okay? So someone has an existing patent on a car with an engine, but I come along and I invent a car with a 6-cylinder engine. And this is a huge improvement, okay? 6-cylinder engine car is my invention. So the question is, does my invention, the car with the 6-cylinder engine, infringe on the existing patent, which is for a car with an engine? This is really tough. So what do you guys think? Does my invention with the 6-cylinder engine infringe on the existing patent, the car with the engine? What do you guys think? I'll give you a second to lock in your answers in the Q&A. Okay, I see it depends. Yes. What else? What do you guys think? I know it's a tough one. Okay, looks like we're getting some good answers here. Yes, my invention does infringe. I still have a car with an engine. It does have 6 cylinders, but the number of cylinders is not relevant here. I infringe on the earlier patent because I still have a car with an engine. Okay, so let's make sure that we're clear here, because this is really difficult stuff here. Patentability is going to ask, is my invention patentable? Okay, I can still get a patent on my invention, the car with the 6-cylinder engine, even if practicing my invention would infringe on someone else's patent. Whereas freedom to operate is going to ask, will practicing my invention infringe on other people's patent rights? And this is super critical to understand before you launch your company or your product, because if you're going to start selling a product, even though you have a patent on it, but in practicing or using or selling that product is going to infringe on other people's rights, that's going to create a lot of problems for you. So I may infringe. So what do I do? And I say may because as a patent attorney, we never want to admit infringement. So what happens? Do we give up? Certainly not. What are we going to do? We're going to build what I like to call an arsenal of our own patents. We're going to build walls around our new products. Because remember, we can still get a patent even though practicing our patent might infringe on other people's rights. And this is going to do a number of good things for us. First, it's going to act as a natural deterrence from other people. So if someone else wants to enter into the car market, they might do a search and see, oh, well, Brad's got all these patents around cars and with 6-cylinder engines. I don't even want to deal with it. So natural deterrence effect, but it's also going to give us an opportunity to do cross-licensing. And I think I saw someone mention this in the chat, so good for you for doing that. What is cross-licensing? Okay, great question. It's got nothing to do with your driver's license. So let's go back to this example. Company A now owns the patent on the car with the engine. Company B owns the patent on the car with the 6-cylinder engine. So what cross-licensing means is that Company A is going to give a license to Company B so that Company B can make a patent, can make a product with a car with an engine, and Company B is going to give a license to Company A so that Company A can now practice the patent, which is the car with a 6-cylinder engine. And in the end, everybody gets what they want, which is making the new technology, which is a car with a 6-cylinder engine. And this is a great technique to get out of litigation. But remember, if company B just gave up and didn't get a patent or a number of patents on their new invention, they would have nothing to negotiate and nothing to license back to company A. So with that, I will pass the Zoom over to my colleague Ariel, who is going to tell you about the next topic of the day.
Okay, thanks, Brad, for covering several great topics. And now we're moving on to the last section of this presentation. How do I know if my invention is patentable? Okay. We'll start by searching prior art references. So why do we search prior art? It's to see what has been done by others, so we can figure out what's patentable in our invention. So remember that your invention needs to be number 1, new, and number 2, non-obvious in view of the prior art. So where do we start? There are a few options, but I like to start with Google Patents. It's pretty much just like regular Google, but designed specifically for patents. And you can type in patents.google.com. And of course, like Google, it's free. And so let's start by doing an example. So this is a product that we've previously worked on. It's a car-shaped convertible backpack. And when it's zipped up and assembled, it's a backpack. And it's a car, car-shaped backpack. And then when it's opened up, the zippers open up, you can unfold it into a flat activity pad. So what we will do is start very broad in a Google search just to see what's out there and kind of to see what kind of terminology other people are using, and then we can do a more focused search later. So I would start by typing in just a natural language searching, just as how you would on regular Google. Here I typed in car-shaped convertible backpack, and you'll notice that Google has automatically inserted semicolons next to each word, and that just means that it's prioritizing search strings with all these 4 words present. So it pretty much means you're searching car and shaped and convertible and backpack. Okay, so in this example, we returned 179 results. It's a little bit more than I like, but since it's a broad search string, it's okay. And then we'll go down by looking at the title because it gives you a pretty good idea of what the invention is about. This first one is called a convertible baby carrier. Not so close to what we're looking for. Moving on to the next, it's airplane safety seat for lab children. Still not very close to what we're looking for. Remember, we're looking for a car-shaped backpack that can unfold into an activity pad. And this next one is a convertible carrier. It's good, actually. It's quite promising, so we'll try to click into it and see what this one is about. And if you click on the result, this text searchable version of the patent appears. And it's quite convenient that Google has highlighted the search terms that are relevant. For example, the convertible is in a darker blue and the backpack is in a lighter blue. So it's easier for you to review the portions of the reference of interest. And here we can briefly look at the abstract. It's a little bit close, but not quite. And the pictures show this backpack, and it's pretty clear it's not very close to what we're looking for. But now we've got an idea of what kind of keywords we should be using, and we can move on to a more focused search. And that's what we're going to do. So now we're going to try to find the closest prior art and any knockout references, which would hopefully disclose exactly what we want to patent. And so how do we formulate the search string? We should try to first list the function of the invention. And here we know the function is converts between storage container and the activity mat. And second, we should try to list all the structural elements of the invention. And here we know it's a car-shaped. and which means it'll have curved edges when assembled, and then when it's flat and unzipped, it folds into activity map. And it has two zippers, which would follow the curved path, and it should have a base portion, which would be the base of the car when it's assembled, and it has two side portions, which are the doors of the car, and it has a lid flat portion, which it can unfold and fold. So then we would go on the next step. We'll run a more pointed search using the search terms we just discussed. Here I've tried to put in storage container, car shape, flat activity mat, zippers, base, sides, lid. So we try to list the components we discussed, and we listed the functions. Okay, sorry. Just here. Okay, so now we have about 33 results, which is a lot better than last time, and it's quite manageable even if you want to go through every single result. And also on the left side of the screen, under the heading search terms, you can tweak and modify all of the individual terms Google used in the search. So if you don't like something, here you can still modify on the left side. Okay, here you'll see that naturally for storage, Google is also including synonyms, which is quite nice. So if another patent is using something like not something close to storage, but not exactly storage, it will still pull up. And for some reason, if you want to search for a very, very specific word, you could put quotation marks around the word, so Google would know not to search for synonyms and this time only search for the specific word. But here for this example, we're actually interested in the synonyms of these words. So in the future, if we think a term is too narrow and it returns too few results, we can try to include more different ways of describing something, so we could get more than 33 results. But here again, 33 is a good number. Okay, so we'll look at the first one. The first example here is convertible storage container. It actually looks really good, and we're going to click into it and see what's up. And we're opening up this link, and it shows a text searchable version of the patent titled Convertible Storage Container. And again, the phrases of interest are highlighted here, and it actually hits quite a few of our keywords like orange for storage and purple for container, green for activity, quite close. And what we're going to do is try to download the PDF over here, and it pulls up an actual printed version of the patent. I like to do that because nowadays it's also searchable. Google tried to make a more recent patent searchable, so you can search within the PDF there. And also it's easier for me to view the figures than trying to toggle over here on the web page for the images. So let's try to open it up, and we will go through the patent to look for the figures and look for the claims, because remember, claims are what define a patent. And here we see the figures 12 and 3 are quite similar to what our invention is. And claim 14 kind of describe what we want to describe. And in the interest of time, we're not going to go through this claim, but it's quite close. So let's compare the results with our invention and try to note the differences. And it's important to know the differences because nowadays, like Brad said earlier, almost every element is known, especially in the mechanical field. So most inventions now are combinations of known elements in a novel and inventive way. In other words, when the differences are novel and inventive, it would be eligible to get a patent. And here, see, like the figures 12 and 13 are actually really close to our invention. Well, that's because the patent is our invention here. That's exact match. So to conclude, we have a few key things to remember. Number one, get an NDA before disclosing your idea to third parties. And remember, it does not protect from offers for sale. And that would trigger the 1-year bar in the United States, and other countries might have absolute, novelty here. So, and number two, intellectual property options are not one size fits all. So remember, other than patents, you could also get trademark and copyright protection, or you could get just trade secrets protection. And number three, a patent grants you the right to exclude, but not a right to practice your invention. And that's why a freedom to operate is really important if you're launching a new product. And number four, filing a provisional application permits the use of the magic language patent pending, which would be a great marketing tool. And number five, you can protect the aesthetics of your invention with a design patent, including your user interfaces for apps. And number six, find your patentable features by focusing on the non-obvious differences between your invention and the closest prior art. And because almost all inventions nowadays are combinations of known elements, that's why the differences are so important for you to know. And remember earlier, Brad mentioned the software is patentable. And when in doubt, call your patent attorney. Okay, thank you.